Thank you.
Mr. Chair.
Mr. Chu? So we do have a motion and a second. Thank you. Let me make one comment, and then I will let you close. And then we'll move on to the vote. And just, Mr. Gallagher, I'm sorry that you missed the conversation that was happening here prior to when you came in. But some of the comments that were talked about was it is a fundamental part of public policy in the state of California to protect the workforce and to ensure that public work is being done by public employees. And if you translate that as merely benefiting the unions as opposed to the workforce, that's your perspective. But I think most of the folks here and most folks throughout California value that as California public policy, which has been fairly clearly established for a long period of time. And with that, Senator, you may close.
Thank you, Mr. Chair, and thank you, committee members, for your comments. I just want to challenge Assemblyman Gallagher's frame of this. If the bill were as interesting as the Assemblyman has defined the word, I doubt that I would be authoring this bill. I'm authoring this bill because I am standing on the belief of the tangible concepts of accountability and transparency and due diligence. It has never been proven that contracting out is cheaper, more efficient, or better at delivering services to the public than for public employees. It just has not been proven. So this is about good government. This is not inventing anything new. This is what every other aspect of state government already abides by. Standards and protocols. Just be able to analyze and document that there will be cost savings, that employees will not be displaced as a result, that there is accountability. And if, again, as the chair pointed out, you turn to page 4 of the bill and look at the long list of exemptions, this has been thoughtfully considered, and I would ask for your aye vote.
Thank you, Senator. All right, the motion is do pass as amended to appropriations. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner.
No.
Wagner, no. Alejo. Alejo, aye. Chow. Chow, aye. Chu. Chu, aye. Gallagher.
No.
Gallagher, no. Garcia. Garcia, aye. Holden. Holden, aye. Mainshine. O'Donnell. O'Donnell, aye.
Your bill is out. Thank you, Senator. And that brings us to Senator Hill, item number 3, SB 658.
Good morning, Mr. Chair and members. As you can see in the analysis, this bill is supported by many organizations because it will lead to more AEDs in the community. Automatic external defibrillators are the most effective way to save cardiac arrest victims. Sudden cardiac arrest kills nearly 1,000 people every day in the United States. Only 10% of victims who suffer a cardiac arrest outside of a hospital setting survive. The average response time for a 911 call is 8 to 12 minutes. Each minute defibrillation is delayed, a person's chance of survival is reduced by 10%. It's critical that we get more AEDs placed in all types of buildings and businesses around the state. One of the best ways to increase the number of AEDs is to update the AED liability immunity requirements that were established by this legislature in 1999. The requirements from the 1990s were based on older AED technologies that didn't have voice commands, didn't have pre-connected shock pads, didn't have long-lasting batteries, didn't have voice command CPR coaching. The new generation of AEDs are so simple and user-friendly that nearly anyone can successfully administer them without training or practice. They even have a built-in computer that monitors the heart rhythm of the cardiac arrest victim to determine if a shock should be administered. The bill requires building owners to ensure that batteries are checked, AEDs are maintained, tenants know where the AED is located, instructions are posted next to the device, and a demonstration is provided annually. It also modernizes the requirements on schools, so principals are more likely to install them. A study by Johns Hopkins University found that Good Samaritan access to AEDs doubles survival from sudden heart attack. According to the U.S. Department of Health and Human Services, there have been no reports of AEDs harming users by bystanders. According to the National Institute for Health, quote, learning how to use an AED and taking a CPR course are helpful. However, if trained personnel aren't available, untrained people also can use an AED to help save someone's lives. I have some witnesses, and I respectfully ask for an aye vote, members.
Thank you, Senator. Your witnesses in support.
Greg Herner with Carpenter Severs on behalf of El Camino Hospital, a nonprofit community hospital. I would say El Camino is also co-chair of the Health Committee of the Silicon Valley Leadership Group, and they'll also be testifying or offering their support today. As Senator Hill mentioned, 1,000 times a day somebody in the United States dies from sudden cardiac arrest, and there's a 90% death rate from this. But it doesn't have to be this way. AEDs have a remarkable track record of safety and efficacy. And keep in mind that anybody can go to Costco and purchase one of these without a prescription. El Camino Hospital has been working with local EMS authorities, local government school districts, and nonprofit businesses in their community to try to make AEDs as available as fire extinguishers in the community. But the problem is there's not nearly enough right now. And second, because of the laws, it's discouraging the installation of these. 2 property companies in Santa Clara Valley with over 80 buildings were approached to install AEDs. Once they were informed about the law and the requirements for installing AEDs, they decided to put AEDs in just 2 of those buildings. For every minute that it's delayed, you have a 10% reduction in your ability to live from sudden cardiac arrest. So you can imagine having to run from building to building to try and find an AED is a very serious and a timely issue. 2 hotels similarly did not install AEDs once they found out the requirements. A yoga studio, business on and on. Even schools were concerned about installing in AEDs. El Camino has used some of their public benefit funds and cooperated with Santa Clara Valley to make over $500,000 available with schools to install these devices. We're waiting for the change in this law that Senator Hill's offering so that those businesses and those schools will actually make these available so that they can save lives. And just as a note, I walked around, and for most of your staff, I did demonstrations with an AED from the trainer from the nurses station, and I encourage anybody to go view them if they have never done so. I picked the fellow or the foster youth or the youngest person in the office and simply handed them the machine. There's a 100% success rate of them hooking up the AED and being able to utilize it. And while that clearly staff are very professional here in the building, that jives completely with when AEDs were provided to 6th graders, and they were also able, at almost 100% success rate, to use an AED with absolutely no instruction. So these are very simple devices to use, and we strongly encourage your support of this bill.
Thank you. Next witness, and I'll remind witnesses that the recommendation is support.
Thank you. My name is Heath Wakely, and I'm a volunteer for the American Red Cross. I'm a board member. I'm a CPR and AED instructor, and also a disaster action team captain. I won't. No need to repeat what's already been said. I think the comments already have been excellent. 2 comments that I would add. I live in an over 55 community. We had 2 AEDs on site, but they were removed because of the way the legislation is currently written. I strongly encourage you to pass this legislation, pass it on, so we can get our AEDs back. We have 685 homes in our community now without an AED. Also, a reminder that for sudden cardiac arrest, early defibrillation, if it started within 3 minutes of cardiac arrest, that 7 out of 10 lives can be saved. And that's significant. I'll just close and say that the American Red Cross is in support of 658. Thank you.
Thank you. Other witnesses in support? If you'd state your name, your affiliation, and that you support it, please.
Mr. Chair, Chris McKaylee on behalf of my clients, the Civil Justice Association of California and the California Ambulance Association, in support.
Thank you.
Alexandria Felton from the Silicon Valley Leadership Group, in support.
David Ford on behalf of Stanford Healthcare and Lucille Packard Children's Hospital, in support of the bill.
Misty Johnson with Nielsen Merksmer here on behalf of Phillips Electrics, in support of the bill. Jean Hurst on behalf of the Association of California Healthcare Districts, also in support.
Michael Radigan on behalf of the Board of Supervisors, Santa Clara County, in support.
Matthew Hargrove with the California Business Properties Association, here today on behalf of the Building Owners and Managers Association and the International Council of Shopping Centers, in support. Thank you.
Mr. Chair, members, Monica Miller on behalf of the County of Santa Barbara, in support. Thank you.
Thank you. Anyone else in support? Is there anyone in opposition? Seeing none, I'll bring it back to the committee. There is a motion and a second. Questions, comments? Seeing none, Senator, you may close.
Respectfully ask for an aye vote, members. Thank you.
Thank you. And the motion is due pass. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
Thank you, Patrick.
The bill is out.
Thank you, Mr. Chair. Thank you very much, members.
Thank you. Brings us to item number 1, Senate Bill 196. Senator Hancock.
Good morning.
Good morning.
Mr. Chair, members of the committee. I'd like to start by accepting as authors' amendments, the amendments detailed on page 5 of the analysis. These amendments basically clarify the intent to allow an adult protective services agency to seek a protective order, but not to alter any of the evidentiary requirements for obtaining the order. So I want to thank the committee staff for working with us on this clarification. SB 196 provides a narrow ability for adult protective services to file a petition for a protective order when a conservator is being sought, but there is a need to step in and stop abuse while the lengthy conservatorship process is decided. Until, a criminal case is filed or a temporary conservatorship is in place, county agencies rely on more general protective orders that are not adapted to the unique issues of elder abuse. These protective orders include emergency protective orders or restraining orders, mainly designed to prevent physical harm and abuse. And in the case of restraining orders, it presumes the victim has the ability to initiate the request. However, cases of elder and dependent adult abuse are often complex. The victim is often unable to advocate on their behalf, but has not yet been placed in conservatorship. Time can be very, very important in protecting assets and stopping abuse in these cases. But it may take law enforcement several days or weeks to gather the evidence and to file a case with a district attorney's office or a prosecutor. While the process of charges are being filed, protective orders need to be available to protect assets and further abuse. SB 196 authorizes a county adult protective services agency to file a protective order on behalf of an elder or dependent adult only when the elder or dependent adult has suffered abuse and has an impaired ability to understand the circumstances or risk of harm, or has provided written authorization to the agency to act on their behalf. To ensure due process, the agency filing the petition will alert the elder or dependent adult and make reasonable efforts to have them attend the hearing. and also will have to file concurrently or previously to start the formal process of conservatorship. As with any protective order, a court would review and approve or deny the request. And, we know that Adult Protective Services has always been a voluntary program, and that some people who are not impaired may choose not to seek protective orders or accept assistance, even when it may appear to an outside observer that they are being abused or neglected. The agency would not file a petition in these situations. That is the elders or dependent adult's choice. So this is only for when someone either asks for assistance or when the APS agency is confident enough that the individual has impaired ability to understand the harm he or she is in, and a conservatorship is being sought on their behalf. With me today in support is Kathy Senderling McDonald with the County Welfare Directors Association.
Thank you. We do have a motion and a second. So your witnesses and supports.
Great. Thank you, Mr. Chair and members. Kathy Senderling McDonald with the County Welfare Directors Association. We're very pleased to sponsor this legislation. What we're trying to do with this bill is just get the Adult Protective Services departments another tool in their toolkit. It's very much aimed at the most egregious cases, situations where that conservatorship referral has already been made or a conservatorship has even been filed, and abuse is actively occurring and continuing in the meantime while that conservatorship is being put into place. The checks and balances in the bill that we continue to make small tweaks to, as you saw in the author's amendments, we very much appreciate that continued input from the committee and from the field to ensure that the referrals are made, the conservatorships are filed timely at the same time or before this petition would be brought, and the court process then has the ability to play out to ensure that the case is made, that this situation, the impairment is there, and that the abuse is occurring and will continue if something is not done for a temporary restraining order to be provided. We really appreciate this. Time, as Senator Hancock noted, is really of the essence in these cases. If Adult Protective Services can get in there and start to help the elder or dependent adult before the abuse gets worse, our job is that much easier to try to help them get back on a path, remain healthy, and remain in their homes to the greatest extent possible. Thank you for your support, and I'm happy to answer any questions.
Thank you. Next witness, please.
Greg DeGier, representing the ARC and United Cerebral Palsy California Collaboration, a coalition of people with intellectual and all developmental disabilities, and their families, friends, and service providers. We support the bill. The term dependent adult is a bit misleading in that it actually covers people with disability, adults with disabilities, regardless of the fact that most of them live independently. And they are, in the case of people with developmental disabilities anyway, subject to very high levels of abuse, whether they are truly dependent, living in a developmental center or something like that, or living out in the community, and we support the bill.
Thank you. Next witness.
Libby Sanchez on behalf of Laborers Local 777 and 792, representing APS workers throughout the state. We're very appreciative of the clarification in this law and the consistency it will provide to our APS workers. Thank you.
Thank you. Other witnesses in support.
Thank you, Mr. Chair and members. Farrah McDade Ting with the California State Association of Counties in support.
Thank you.
Yes, Mr. Chair and members, Jolena Voris on behalf of the Urban Counties Caucus in support.
Mr. Chair and members, Brian Allison on behalf of the American Federation of State, County, and Municipal Employees, also in strong support.
Good morning, members. Braden Obrowski on behalf of the California Association for Health Services at Home in support. Thank you.
Latoya Ramsey, National Association of Social Workers, California chapter, in support.
Michael Radigan on behalf of the Board of Supervisors, Santa Clara County, in support.
Thank you. Anyone else in support? Is there any opposition? Anyone in opposition? Right, seeing none, I'll bring it back to the committee. Questions, comments? Seeing none, Senator, you may close.
I would respectfully ask for your aye vote.
Thank you. The motion that has been made is due pass as amended to aging and long-term care. Call roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Alejo, aye. Chow?
Aye.
Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
Your bill is out.
Thank you very
Thank you.
much.
And as Mr. Alejo gets ready to present AJR 19, which is item number 6, I'll take a motion on the consent agenda. So we do have a motion and a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
So those bills are out. That is SB 68, SB 363, and SB 594. Those were the three bills on the consent agenda. Mr. Alejo.
Thank you, Mr. Chairman and members. I'm here to present AGR 19, which urges Congress to allow immigrants who are eligible under the President's executive orders for deferred action for childhood arrivals, or DACA, or deferred action for parents of Americans who are also lawful permanent residents, DAPA, to serve in the U.S. military. Just to provide some brief background, this past April, the House of Armed Services Committee passed an amendment, the National Defense Authorization Act, or NDAA, urging the Secretary of Defense to consider allowing DACA-eligible immigrants to serve in the military. The amendment had bipartisan support, but unfortunately, bowing to pressure from fringe interests, the full House voted in mid-May to strip away the amendment when the NDAA came before the full House. Currently, less than 1% of the U.S. population serves in the armed forces. Compare that with more than 12% during World War II. But yet thousands of immigrants have served and continue serving vital roles in the military intelligence, information operations, including foreign language translators, interpreters, and cultural experts, making them an essential resource to our national defense. In closing, the majority of immigrants covered by the President's executive actions have lived in the United States most of their lives. This is a country they only know. They are Americans for all intents and purposes, and allowing the resolution, this resolution request, and all this resolution requests is that Congress give them the opportunity to serve their country in the armed forces. I just also want to point out that the first person to sacrifice his life in the war in Iraq was an immigrant from Guatemala, and was only granted citizenship posthumously after his death. And that's also the story for about another 118 immigrants who also have sacrificed their lives in the wars in Iraq and Afghanistan, and were granted citizenship posthumously as well. But also, as we're having this discussion, we should all know that since 2009, 53,000 immigrants who have served their country have taken advantage of the expedited citizenship after serving their country in the military. We should continue to provide this opportunity for those who are willing and able. I respectfully ask for an aye vote.
Thank you. Do you have any witnesses in support? Anyone in support? Seeing none, is there any opposition? Seeing none, I'll bring it back for... We do have a motion and a second. Questions, comments? Mr. Gallagher?
So, Member Alejo, you know I understand your motivation is a good one here. You and I both agree that our immigration system is broken. It needs to be fixed. There should be a process, a better process that allows people to come here, work here, and get into a process that we don't have right now. But we have to respect the process that's been established, that Congress shall make law to establish these things, and I think we should care about the process. And so these bills that have come through where we're sort of assuming that DACA and DAPA are constitutional, even though there's current litigation, that those executive orders may be found unconstitutional. We're trying to move forward as if this is law when it's not law. And so, though I agree with the motivation here, which is to allow people who have been established as legal residents, who have been established as citizens by the legal process, to serve in our armed forces. I wholeheartedly agree with that motivation. What this is doing is saying that people who have not been established as being legal residents, and I think both of us are lawyers and legislators. We should care about the fact that the executive is going forward and making law, usurping power away from the legislative branch. And nobody understands this frustrating process more than me. and being a Republican in this legislature, right? I'm in the minority. I don't get to make the decisions. Things that I'd like to see move forward don't, but I respect the process. And I provide my input, as you already know. But I respect the process, and I respect the legislative committees, floor, and the process that we go through to make law. That hasn't been done at the federal level yet. So for us to move forward like it has, to me, is not respecting that same process that we all adhere to here. So even though I understand your motivation moving forward, I can't support the bill because we're assuming that DACA and DAPA are constitutional, and I don't think they are. Because I don't think the executive branch has the power to make immigration law. Congress does. And as frustrating as that process may be, I think we need to respect that process that was established for all of us, and that we all, each and every day, go about doing, even though we may not always get our way, the things we want. If we go by a process of the ends justify the means, what makes us any different than the despots around the world? If the executive can just usurp the legislature and we don't follow the rule of law that we've established for ourselves, what makes us any different? Even though you might agree with the goal this time, what if somebody starts using executive orders to do things you don't like? When we've seen that power abused in the past. So as much as we may like what the president has done with these executive orders, it is an abuse of the process, and I think we should all care about that. And that's why I won't be supporting the bill.
Well, not supporting this resolution and what was proposed in Congress is a lack of respect for the immigrant families who have sacrificed their lives serving this country. I'm the son of a Vietnam-era veteran, and when you see the people who have paid the ultimate sacrifice, that they could give their lives fighting for their country, but yet their Congress and their state legislators are saying, we're not going to provide a path for those who have paid the ultimate sacrifice and their family members, I think that's disrespectful. And the fact is that since 1986, Congress has failed to act to provide some relief. I think that if there is one area that we can agree on, is that we provide a path to legalization for those who are willing to pay the ultimate sacrifice and serve their country in the military. So this would be without question. The problem is that the fringe elements in Congress have blocked this proposal, even though it did have bipartisan support. And frankly, the comments that you just made seem out of touch with even your Republican colleagues here in Sacramento, who have made efforts to build bipartisanship around supporting comprehensive immigration reform. I think we've shown that in Sacramento we could set the example for Congress and for the rest of the nation, that we could try to find a middle ground, a pathway to help our immigrant families who only want to serve their country. And in fact, it was, as a analysis points out, it was last September of 2014 that the Pentagon announced the MAVNI program to allow immigrants who qualify for DACA up to $1,500 per year to be able to enroll and be able to benefit from a program to serve in the military. And the reality is that what is being challenged isn't the first DACA program. That is in place, that continues to be in place. What is being challenged in the federal court is the new DACA and DAPA program that the president has proposed. The existing program is the law. It is in place. Those who qualified are able to renew and continue to benefit from that executive order and that program. So your analysis is inaccurate. But if we're going to truly honor our men and women who serve in the military, regardless of immigration status, we should all find bipartisanship and support this resolution and send a message to Congress that this is the right thing to do for those willing to sacrifice for their country.
Mr. Wagner? Oh, I'm sorry. Mr. Gallagher, you're not done yet?
Well, what I was just, my response was just going to be that if that's not what this resolution does. It doesn't say if someone has already served. Your resolution says it authorizes people who are not yet established here as legal residents or as citizens to serve. So the resolution isn't about people who have already served. It's about authorizing people who are not here legal to serve. And you made my point for me, because under the legal program that is established law, we already are providing that opportunity for people to serve. And I think they should. But your resolution is asking for a program that has not been ruled constitutional, that is not the law of the land, and that I would argue is an usurpation of our legislative authority, and asking me to authorize it under that. That's where I'm saying we shouldn't authorize that, because it wouldn't be legal, and because it would be not respectful of the process that we all agree to abide by when we swear an oath to uphold the Constitution. So that's the only place where we disagree. But I think it's fundamental.
If you are arguing that those who are eligible under the prior DACA program should be able to serve in the military, then by extension you would agree that those who would qualify under an expanded DACA or the new DAPA program should also be able to serve the country in the military if they meet all those similar requirements under the prior DACA program. What this is not saying that they should. This is saying that Congress should act. That if there's an area where Congress should be able to find agreement to allow, through Congress, to allow people to serve in the military, it should be those who qualify under DACA and DAPA without any question.
Thank you. Mr. Wagner.
Well, I wasn't going to wade in because I think Mr. Gallagher made some good points, but I do need to push back just on a couple of things. First of all, in response, the author talked very passionately and appropriately so about the men and women who have lost their lives in service to this country, who have, to use his phrase, and the one we all use, made the ultimate sacrifice. Those aren't the subject of this bill. So while we can talk about them and show respect for them and recognize that perhaps folks in those circumstances, not perhaps, in my mind, folks in those circumstances absolutely deserve citizenship, unfortunately posthumous. Okay, that's not this bill. This isn't even a bill, it's a resolution, which brings me to the second point. Yes, it's true, many on my side of the aisle have voted for some of the bills that have come before us dealing with our undocumented community, and there's been some division within the GOP on those issues, but some of us have, in fact, as the author correctly points out, supported some of those bills. Those were actual bills, affirmative law, steps in the right direction. This is just an AJR and urging Congress to do something. So I think the point made by my colleague, Mr. Gallagher, is that it's perhaps premature until we get the full scope of DACA and DAPA resolved by the courts and determine whether this is in fact something that is within the executive power as opposed to within the legislative power. All we're doing is spinning our wheels and making arguments about the ultimate sacrifice that really aren't in the bill. That said, I don't know yet what I'm going to do with the resolution, so not that you care.
Yeah, no, I do care because
Mr. Alejo, I'm going to why don't you respond, and that can be your close, and we'll move to a vote.
Very good.
So
close
please,
now.
Please.
Okay. Well, actually, the legislature has weighed in a bipartisan fashion on bills that impact immigrant families in California and resolutions. A resolution in 2013 that was co-authored by numerous Republican legislators calling for comprehensive immigration reform. And in September of 2013, 15 Republican legislators held a press conference, the first ever in this building, in support of immigration reform. So we have weighed in on legislation and resolutions together, including the one authored by Senator Vidak this year, also calling for comprehensive immigration reform, a bipartisan way calling on our Congress members to do the right thing. That is what we're doing here as well. And what we're talking about is similarly situated immigrants who were born abroad but grew up in this country, and all they want to have is opportunity to serve the country, and in return they should have a pathway to become legalized for serving their country. That is what we're talking about here. If we can't agree on those who are willing to serve in the military, who can we agree on? And I think this is, I'm pushing this resolution because it's just so disappointing that even when it comes to those who are willing to serve the country in the military, our Congress has been unable to find bipartisan agreement on that. That's what's disappointing. And I think what we could do with the state that has the largest immigrant population, more than any other state, that's why we're weighing in. It's that important to California. This is important to our residents, our families within the state. We have the largest population of immigrants, and this is certainly a policy issue that we should weigh in on and send a message to our congressional delegation from California and those throughout the other states. I respectfully ask for your aye vote.
Thank you, Mr. Alejo. So the motion is that the resolution be adopted. Call roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo?
Aye.
Alejo, aye. Chow? Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
No.
Gallagher, no. Garcia?
Aye.
Garcia, aye. Holden?
Aye.
Holden, aye. Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Thank you. That resolution is out. That concludes the business on our file today. If anyone would like to, all the bills are out. If you'd like to add on, this is your opportunity.